All right. So last time we talked about, general terms about the civil litigation process. Today we're going to kind of back up a step and we're going to ask a more basic question. And that is before any of that can even happen, like the pleadings, the discovery, the motions, the trial, who even gets to hear the case at all? Okay. So, this chapter is about the courts and the jurisdiction, and I want you to think of it as the chapter that answers a single practical question that every single litigator and every paralegal that's supporting a litigator has to answer before a single pleading is even drafted. And that is which court has the authority to hear this dispute? Which location is the proper one to file in? Okay. So, everything that we do today is going to build towards being able to answer that question competently. Now, I'll be honest with you. Jurisdiction has a bit of a reputation for being one of the driest topics, and I don't think it necessarily has to be. Jurisdiction is really a story about power, about which government, about which specific courthouse within that government, has been, given the authority to reach out and to bind these parties into this decision. Okay. So once you kind of see it that way, I think the rules start to make a lot more sense because you can ask at every single turn, why would we want that court and not some other court to have this power? Okay. So think about how different that feels, from like the last time that you personally dealt with a legal document, maybe signing a lease or clicking I agree on a set of terms, or, maybe you were just downloading an app and you just, click right on through. Well, buried in every single one of those documents is language about jurisdiction and venue, and it's usually in the tiny print that's near the bottom of the content. Okay, companies negotiate those clauses very deliberately because they know exactly what we're about to spend, the next however many minutes this lecture takes. And that is where the case gets filed can actually shape the entire outcome, sometimes before a single fact is even argued. Okay, so let's dig in. Now let's pause for a minute and just kind of look at what you should walk out of here, able to do today. Okay, so by the end of this chapter, you should be able to describe the function of the trial courts, the appellate courts, and the courts of last resort. All right, your Supreme Courts. In other words, what job each level of court actually performs. You should be able to identify the basic structure of both the federal and the state court system, or at least the typical state court system, because those two systems run side by side. Okay. And a huge part of practicing law, and working in the legal field is knowing which jurisdiction you're in, which court system we're in, all of those things, right? You should be able to distinguish, four related but different concepts, and that is subject matter jurisdiction, personal jurisdiction, in rem jurisdiction, and venue. All right. Now, I want to be upfront that students will routinely kind of blur those together. And it's because they sound familiar. They're not the same question, and confusing them is probably the single most common mistake that I see. Um, you can actually probably stop 10 paralegals, 10 lawyers, and ask them to define, venue and personal jurisdiction in one single sentence. And at least half would give me answers that accidentally describe the same concept twice. Okay. So we're going to slow down and kind of keep them separate all the way through. Okay. And I'm going to keep testing you on the distinction throughout the lecture and not just at the end. You should also be able to explain at an introductory level, federal question jurisdiction and diversity jurisdiction, which are the two main doors, to go through in order to get into federal court for a private civil case. Okay. And finally, you should be able to actually do something with all of this, like analyze a basic where should this be filed problem, okay? In the same way that a litigation team would when a new client walks through the door for an intake interview, like well before, any drafts have happened at all of a complaint or anything, okay? Now, you have a core question here, right? And I want it kind of sitting in the back of your mind for the rest of the semester, not just today. And that is before filing a lawsuit, you always ask, does this court have power over this type of case? Does it have power over these particular parties? And is this the right location? All right. Simply put, type of case, these parties, this location. All right, 3 questions. So hold on to that. We're going to come back to it again and again. And by the time we reach the end of the chapter, I want that kind of 3-part sequence to almost feel kind of automatic, the way that you kind of automatically check your mirrors before you change your lanes. All right, now let's make this concrete right away with a scenario, okay? And we're going to carry this scenario all the way through the whole chapter. All right, and we're going to come back to it at the end once we have like all the tools to answer it. All right, so you have a consumer who lives in Georgia and they buy a product online from a company that is headquartered in California. Okay, now let's say that it's a set of wireless earbuds. It's got a rechargeable, lithium battery. It was purchased through the company's website, right? A few weeks later, the battery in the earbuds, it overheats, starts a small fire that ends up damaging the consumer's home, ruins a laptop, some furniture, things like that, okay? The consumer wants to sue the California company for the financial loss. All right. So the question on the table is simple to ask, and you're about to see that it's not simple to answer. And that is, where could this suit be filed? Notice I didn't ask where should it be filed. I asked where could it be filed. And that's because there may be more than one lawful answer. And part of being a good legal professional is understanding our full menu of options before you pick one. Okay. Now, this isn't unusual, all right? Real intake interviews rarely arrive, with the jurisdiction question already solved, okay? A client walks in upset about a fire, a car accident, a breach of contract. They all want to know if they have a case, and figuring out where that case could even be heard is often the very first piece of legal work that anyone does on the file, sometimes before the complaint is even outlined, okay? To answer this, we actually need 3 separate analyses, okay? And I want you to hear these as 3 distinct kind of doors that you have to walk through, not one big, fuzzy question, okay? First is the subject matter. What legal claim is actually being asserted here? Is it a products liability claim under state law? Is it a breach of warranty claim? Maybe a claim under a state consumer protection statute. Does federal law create any basis for hearing this in federal court, or are we stuck in state court? We got to answer all of those. Second is personal jurisdiction. Does whatever court we pick actually have the power over the California company? A court can't just reach out and bind a defendant located somewhere else without some legally recognized connection between the defendant and the forum state. All right, and third is the venue. So, assuming that we've identified a court system that has both subject matter and personal jurisdiction, then we have to go to which, specific geographic district or county within that system is proper, or at least the most appropriate place to file. Okay. And I want you to notice something else about this fact pattern. It's deliberately ordinary. There's no dramatic villain. There's no 6-figure fraud scheme. It's just a defective product. But it's a defective product in an interstate transaction, all right? And you have a homeowner who's trying to recover a real quantifiable loss, all right? The ordinariness is the point, because the overwhelming majority of jurisdiction and venue problems that you'll encounter in practice look like this. You have unremarkable facts that nonetheless are going to still require, some careful, structured legal analysis before anyone can, move forward, competently advise the client where to file and things like that, okay? Now, I'm not going to answer this today. I'm going to let it kind of sit there a little uncomfortably until we get to the end. And that's because, it takes working through all of the nuances and trying to figure out where we have it. A court selection problem, it requires more than one answer. Again, it's layered on top of each other. So keep this earbud fire in the back of your mind, because again, we're going to build it out piece by piece. Everything that you need to solve it, and we're going to return to it at the end. Now, before we get into jurisdiction itself, we do need a clear picture of court structure, because jurisdiction rules only make sense when you understand what job each level of court is doing. All right. Think of almost any American court system, state or federal, as organized into three functional layers. All right. Even though the names differ from place to place. Okay. At the bottom, you have trial courts. These are like your workhorses of the system. Okay. And honestly, they're where the overwhelming majority of litigation activity actually occurs. The vast majority of file cases never make it to an appeal at all. They settle, they get resolved on a pretrial motion, or they go to trial and they end with a judgment that nobody chooses to appeal. All right, so trial courts receive the pleadings, they hear the evidence, they resolve the factual disputes. Did the defendant run the red light? Was the contract actually breached? Was the product actually defective? And then they enter the judgments that resolve the questions or the case. Okay. Now, above the trial court sits the Court of Appeals, sometimes also called the Intermediate Court of Appeals, and their job is fundamentally different. They review claimed legal errors in what happened at the trial court level. They're not retrying the case, and I cannot stress that enough, okay? Nobody is putting a witness back on the stand at the Court of Appeals. We don't have a jury box. We don't allow new, exhibits or evidence, okay? They're reading a written record, the transcripts, the pleadings, they're reviewing the exhibits that were already admitted. Okay? Legal briefs, things like that. And we're asking a more narrow question like, did the trial judge, apply the law correctly? Did the trial court judge, err in giving this particular jury instruction? That is fundamentally different from what happens at trial. And it's the one reason that appellate litigation looks so different in practice, because it's built around written argument and oral argument in front of a panel of judges rather than a witness, or rather than witnesses, I should say, and the jury. Okay. Also, one thing I do want to say as well is not every state has the Court of Appeals. Some of them bypass that and they have a two-tier system. All right. And that takes us to the top, okay, which is the Court of Last Resort. And in most states, that's called the Supreme Court. And at the federal level, it's the U.S. Supreme Court. In New York, by the way, fun fact, if you've ever watched Law and Order, you'll notice that your regular trial courts are called Supreme Courts. I don't know why they do that, though. But anyhow, this is the highest court in the system, and in most instances, it gets to choose which cases it wants to review. It's not obligated to hear every appeal that comes its way. That in the same kind of way that the intermediate appellate court typically is. Okay. So think about like the practical consequence of that. For the vast majority of litigants, the Intermediate Court of Appeals is the last real chance at review, because the Court of Last Resort simply won't agree to take up, most cases. So 3 layers, 3 different jobs. The trial courts are going to build the factual record and decide the case in the first instance. They're the court of original jurisdiction, typically. The Intermediate Court of Appeals, they're going to check for legal error. Court of Last Resort is going to provide the final, like, system-wide word, okay? And again, they tend to get to pick their own docket. So keep that 3-layer structure in your head also, because we're going to walk through what actually happens at each level in more detail, and then kind of map this same 3-layer structure onto the federal system and the typical state system. Now, let's kind of look at the trial court more specifically, because that's where the vast majority of your work as a paralegal is going to happen. So, a trial court is, of course, where the litigation begins. It's where that factual record, the thing that the appellate court would later be reviewing, is going to get developed. Okay. So, let's walk through the sequence here. The parties file their pleadings and their motions. That's the complaint and the answer. Those are your pleadings. Might be a motion to dismiss in lieu of the pleadings, okay? Then the parties are going to exchange information through discovery, like interrogatories, your document requests, your depositions. This is where the paralegals are going to spend the most hours. You're going to be organizing, document productions, preparing deposition summaries, tracking exhibit, numbers and things like that, okay? If the case then doesn't settle and it doesn't get resolved on like a pretrial motion, then, witnesses may testify, documents get admitted as evidence, either at trial or sometimes you can have an evidentiary hearing. And a judge, or in many cases, a jury, is going to resolve the factual disputes. They're going to apply, the governing legal principles to those facts, and the court will then enter orders, they'll actually enter them along the way because there'll probably be other motions that come up. But eventually we'll get to a judgment that's going to dispose of the case. Okay. So go back to our earbud fire. All right. If that case gets filed and doesn't settle, then the trial court is where the jury is going to eventually decide the factual questions like, was the battery actually defectively designed? Did the company fail to warn about a known overheating risk? How much money would fairly compensate the homeowner, for the damaged laptop, the damaged furniture, or any other kind of losses? All right. Those are your quintessential trial court questions. They're about facts, they're about evidence, they're about dollar figures. Okay. The and think about how much of your work is going to kind of sit inside of that single sentence, because somebody has to gather the repair estimates. Somebody has to track down, the laptop's original purchase receipt. Somebody has to organize like expert reports on battery defects. Somebody's going to have to prepare witnesses to testify about what they saw and they experienced. Okay. That is kind of the day-to-day life of trial court litigation. All right. Now, put that in contrast with what would happen if the case was appealed after the trial. All right. Suppose the jury found for the homeowner, but the company really believes that the trial court gave, the jury an incorrect, legal instruction on what defective design actually means under the state law. Okay. Again, on appeal, nobody's going to re-examine whether the battery was actually defective as a factual matter. All right. The appellate panel isn't going to reweigh the expert testimony. Instead, the appellate court asks a narrow, purely legal question, and that is, was that jury instruction a correct statement of the law? All right. That's the kind of question that ends up in an appellate brief, and it gets argued from the existing record and not retried from scratch. Okay. Now, here's a key distinction that I want you to kind of take with you. And again, it's worth remembering. The trial courts determine facts and apply the law. The appellate courts primarily review legal rulings made below in the lower courts, in the trial courts, okay? So if you remember nothing else, remember those two things, because it's the dividing line for everything else that we're about to talk about in this chapter. One more thing that I do want to say before we move on is that not everything, a trial court does ends in a full jury verdict. A lot of cases will still resolve earlier. Okay. That might be through a motion to dismiss, like if the complaint doesn't state a valid legal claim, even assuming all the facts alleged are true. You can also do summary judgment. Like if discovery shows there's genuinely no factual dispute for a jury to resolve at all, then you can do a motion for summary judgment asking the judge to go ahead and make a ruling. Okay. Both of those are still trial court functions, and they still fit within that, whole like determine the facts and apply the law description, even though neither of those involves like a full trial with live witnesses. Okay. Most civil cases settle before any of those stages come to be. All right. Sometimes even before the complaint is filed, sometimes in the middle of discovery when they have a more clear picture of what evidence the other side has. That ends up telling them, the risk of proceeding further. Okay. So when we talk about like what a trial court does, we're describing a whole plethora of possibilities that a case can take, and not just like a guaranteed, path that like everyone's kind of marching down. Now let's talk about the whole journey that a case can take through the three level structure, start to finish. Because I think that seeing the full path kind of helps the individual pieces make sense. So it starts at the trial court where the parties build that record and the fact finding happens. Okay. Everything we just talked about. If the party's unhappy with the outcome and believes that the trial court made a genuine legal error, they can then move it to the intermediate appellate court, where that reviewing court is going to examine that claimed legal error, and they can affirm the decision, they can reverse it and remand it. They can send it back to trial, basically, for further proceedings that are consistent with the ruling. And I know that I said, if they're not happy with the ruling, but I also added in and believes that the court made a genuine legal error, because it has to be both. You can't just appeal because you're unhappy with it, okay? Now, from there, a case can sometimes move further, and that would be to the court of last resort. Now, review at that level is going to be discretionary, meaning that the losing party doesn't have an automatic right to have that court hear the case, okay? The court of last resort tends to take up matters that would be considered system-wide significance. So it's going to be questions where the law is unsettled, or where like lower courts disagree with each other, or where the issue is likely to recur in many future cases, okay? And then the case is going to reach an endpoint, either through a final judgment or remand back down to the trial court to redo like some piece of the proceedings, but under like corrected legal standards, okay? I do want to kind of point something out here though, because students do often kind of picture an appeal as kind of a fresh shot at the same case, a do-over, a mulligan, but it is not. Okay, I can't stress this enough. The appeal focuses narrowly on legal errors. Okay, and it has to be something that's significant. Otherwise, it would be a harmless error. Okay, so they're going to focus on, is this a significant legal error that happened in the trial court? Like, was there a wrong jury instruction? Was there an evidentiary ruling that shouldn't have been made? Was there a legal standard that was misapplied? Okay, so if the trial court got the law right and the jury simply believed one side's witnesses over the other, that's not going to be something that an appellate court is going to touch. Okay, appellate courts are not in the business of reweighing credibility. They leave that to the trial level fact finders. Okay. And let me just kind of illustrate that with a couple of quick examples, because the line between a legal error that's worth appealing and just an unfavorable outcome is the kind of judgment calls that, litigators do have to make kind of constantly. So if a trial judge allows a piece of clearly inadmissible hearsay evidence onto the record, okay, and there was a proper objection to it, and that evidence was key to the jury's decision, all right, that is a very strong candidate for an appeal. That is a genuine legal ruling that may have affected the outcome, all right? Now, on the other hand, if a jury simply found that the plaintiff's expert was more credible than the defense's expert, all right, both experts were, properly qualified, their testimony was properly admitted, that's not a legal error at all right? It's the jury doing the job that they were impaneled to do. And an appellate court is generally not going to second guess it. Okay. This is also a good moment to come back to the whole concept of the harmless error, because it does explain why not every legal mistake actually results in a reversal or an appeal. So if, okay, let me back up. Even if a trial court made a genuine error, like admitted something that it shouldn't have or gave an imperfect instruction, then an appellate court may still affirm the judgment if it concludes that the error didn't actually affect the outcome, given the strength of the rest of the evidence. All right. So the path from the trial court to the court of last resort isn't just about spotting an error. It's about showing that that error mattered. It's showing that it would have changed the outcome of the case. Okay. So, as a paralegal working on an appeal, your role is going to shift very noticeably from what it looks like at the trial court stage. So, instead of organizing exhibits for like a jury or preparing witnesses or whatever, you're going to be site checking a brief. You're going to be compiling an appellate record from the transcripts, and exhibits that are already created, below. You're going to be tracking like strict page limits and filing deadlines that the appellate court enforces very rigorously. Okay, it's just the whole thing. It's a different type of work entirely, even though it's still going to use the same underlying case. Um, the discretionary view at the court of last resort, it does deserve kind of one more moment, because the word discretionary does a lot of work in that sentence. Okay. So when a losing party at the intermediate appellate level ask a court of last resort to take the case, that request is typically framed around why the issue matters beyond just the two parties in front of the court. All right. Because again, you have to show that the law in this area is unsettled, or because the lower courts around the state or the country disagree with each other, or because the issue is likely to keep recurring and needs a definitive answer. Okay, so a petition asking for, the court of last resort to hear a case that just re argues, well, the trial court got the facts wrong, is very unlikely to be granted because that is not the kind of case that has system wide significance that these courts are generally looking for. All right, so let's use our three-layer structure for the federal level, because that is the system that governs anywhere federal law is involved. So, at the very top is the United States Supreme Court, and that is the highest federal court. And again, discretionary review in most cases. If you've heard the phrase, writ of certiorari, granted cert, things like that. It refers to a petition for a writ of certiorari, which is how a party asks the Supreme Court to agree to hear a case. Okay. The court grants only a very small amount of these petitions that it receives every single year. It also is a court of original jurisdiction, but in very, very limited cases. Um, Below that is the U.S. Court of Appeals, which is the intermediate appellate courts. And they are organized geographically into what we call circuits. There are 13 federal circuits altogether. And it's like the First Circuit, the Second Circuit, all of that. All of them are numbered except for we have the DC Circuit and the Federal Circuit, which handles, certain specialized subject matter like patent appeals and stuff like that nationwide. So if a case is tried in a federal district court in, say, Georgia, and the appeal from that judgment goes all the way to the 11th Circuit, which covers Georgia, Florida, and Alabama, I believe. Kind of compare that to a case that gets tried in California. That appeal goes to the Ninth Circuit, which covers a lot. I mean, it covers like essentially the Western United States up the coast over there. Um, Now, one consequence, kind of worth knowing, is that because circuits sometimes interpret the same federal statute differently from one another, it is entirely possible for the law on a given federal question to genuinely differ depending on which circuit you're in, okay? Or at least until the Supreme Court steps in to resolve what the circuit, what's called a circuit split, okay? Below the circuit courts sits the U.S. district courts. And those are the general, federal trial courts. And they are also organized by judicial districts. Okay. Some states are a single district. Okay. Larger states get divided into multiple districts. So Georgia, for example, has the northern district, the middle district, and the southern district. And each one covers a different set of counties and each with its own courthouses. Okay. The Northern District of Georgia, sitting in Atlanta, is going to cover the metro Atlanta area and up. The Middle District is going to cover the counties like around Macon. The Southern District is going to cover, the counties around Savannah and down. Now, California being larger, it's going to be divided into 4 districts. You have the northern, the eastern, the central, and the southern. And those are all anchored by major cities like San Francisco, Sacramento, Los Angeles, and San Diego, respectively. Okay. So when we eventually ask where our earbud company, might be sued in federal court, saying California alone isn't a complete answer. We need to know specifically where in California that company is headquartered so that we can identify the correct district. Okay. Then there's also a 4th category that's worth knowing, and those are our specialized federal courts. And those are going to be your trial courts with limited or specialized jurisdiction. For example, the bankruptcy courts, they handle bankruptcy filings exclusively. All right. And they exist as kind of like an adjunct to the district courts. Okay. You also have the U.S. Court of Federal Claims, and that hears monetary claims against the federal government itself. Then you have the U.S. Tax Court, which again is going to handle, tax liability. But these courts don't hear a full range of civil disputes. They are built specifically around a single subject. Okay. And then that case belongs in one of those specialized courts generally, because they cannot be filed instead in like a general federal district court or vice versa. So it's going to start there. Okay. Now, one thing that I want you to keep with you kind of going forward, subject matter. Okay. Federal courts have limited jurisdiction. Okay. Unlike a typical state trial court, a federal court can only hear the cases that the Constitution and the Congress has specifically authorized them to hear. Okay. That limitation is not a technicality. That is a structural feature of how federal power was designed. It goes back to Article 3 of the Constitution. Okay. And it means that just because a case is important or it's big or it involves an interstate dispute or anything like that, it doesn't automatically mean it belongs in federal court. Okay, so a federal judge who suspects, like even mid trial, that the case should never have been filed in federal court in the first place has an obligation to even bring that up. It's not optional. Okay, and it isn't something that, parties can ever simply agree to overlook. Waiving subject matter jurisdiction is never a thing. Now let's look at the state side because, again, remember, most civil litigation in this country by sheer volume happens in the state courts and not the federal courts, okay? So every state runs its own judicial system. And while the details are going to vary quite a bit from state to state, most states still follow a structure that will feel very familiar after what we just covered federally, and that is the 3-level design. Okay, at the base you have the trial courts, though again the naming conventions are all over the place. This does kind of trip people up when they move from states to states. Like here in Georgia, I know that what we call a magistrate court is not what some other states refer to as their magistrate court. Like the roles and responsibilities are very different. Anyhow, in Georgia, we have a general trial court of unlimited jurisdiction, and that is our superior court. Okay. In many other states, you'll hear circuit court, like Michigan and Illinois both use that term. Ohio and Pennsylvania, they use a court of common pleas. Again, like I said with Law and Order, if you've watched that, in New York, their trial court is called the Supreme Court, with the Court of Appeals sitting above it as the court of last resort because they only have the 2-tier system. All right. And it's exact reverse of what most students expect kind of the first time that they encounter it. Some states call their trial courts, county court or simply a district court. Some of these courts have monetary limits on the size of the case that they can hear, like a magistrate court or a small claims division. They get capped at, say a few $1,000s or maybe like $10,000, $15,000. And then if a case, if there's an amount in controversy that is above that, then it has to go to superior court instead, the general trial court. Okay. So never assume that a term that you've learned in one state system means the same thing somewhere else. I can promise you that it just may not, okay? Always confirm the local terminology before you file anything, okay? And alongside the general trial courts, most states do have, their specialized courts. You can have family courts that handle divorce and custody. You've got probate that'll handle, wills and estates. You've got juvenile court that'll handle people who are children who are in foster care on top of children who are delinquents. You have small claim courts, for low dollar disputes. Okay. Those are also in courts, like magistrate court is not a court of record. So there is a very simplified procedure that happens in those courts. And it is designed so that ordinary people can represent themselves without an attorney. Okay. So if our earbud, fire homeowner only wanted to recover, say, $1,000 for, their computer, then small claims might actually be more efficient as their venue, than a full civil suit. It's faster, it's cheaper, it's less formal. But we're talking about more than that. We're talking about a laptop. We're talking about furniture. We're talking about real property damage that could easily run into, tens of thousands. All right. And that's very likely above the small claims cap, which is going to then push the case into that superior court realm. Again, in that area, you have a fuller set of procedural rules. You have formal pleadings. You have discovery. You have motion practice, and all of that comes with it. Okay. And then we have the appellate review, which is your intermediate court of appeals, and then the court of last resort, which again is usually the state Supreme Court, that like our U.S. Supreme Court or our SCOTUS, it sits at the very top of the state system, completely separate, and independent from the federal system that we just discussed. But again, you have the way also for certain cases, once it gets through that, it could potentially be appealed on into the federal, but that's a whole other class. Now, I want to take a tiny little detour here and talk about some of the mechanics of litigation practice and how they've changed over the last couple of decades, because this matters directly in your work as a paralegal. Starting with e-filing, pleadings and motions are now commonly filed through the electronic court systems rather than like being walked into the clerk's office to be done on paper. Okay. In the federal system, it is called the CM, like Charlie Mary, /ECF. What is it? Echo Charlie Foxtrot. I think that's what it is. It means case management / electronic case filing. Okay. Most state systems have their own like equivalent portals. In Georgia, we have Peach Court, and then we also have Odyssey. Odyssey is a little harder to navigate, and it looks like a lot of the courts are kind of steering over to Peach Court, which I find much easier to work with anyhow. Now, as a paralegal, you are likely going to be the person who is going to be responsible for e-filing your documents, which means that you're going to need to know the specific formatting rules, the filing deadlines, and confirmation procedures for whatever court system you're working in, okay? And then those rules can differ, a lot from one court to the next. So you need to stay up on that. Courts also increasingly use remote proceedings as well. COVID changed a lot of that. Okay. So video platforms for status conferences, some hearings, even occasionally some parts of the trial. And that is a practice that, again, it expanded a lot during the pandemic. And it's kind of stuck around in a lot of jurisdictions because it does save time and travel when it comes to routine matters. Before that, you had to basically beg and plead with the court in order to be able to get some mercy there, to be able to use, a telephonic, conference or whatever. Digital records means your dockets, your orders, your filings. These are all commonly maintained and accessible electronically, which is super useful when you need to like check a filing date or, pull an order at 10 o'clock at night before the hearing the next morning. Okay. Then there is electronic evidence. And modern cases regularly involved text messages, emails, metadata, all of those things is like your core evidence, not just like your proper or your traditional paper documents. Okay. So if our earbud company, if it had internal emails that were discussing like a known overheating defect before like the consumer, incident happened, then those emails and the metadata showing when they were sent and to whom they were sent could become central pieces of evidence. Okay. Um, Now, want to kind of leave you with this. Technology, as it says down at the bottom on your professional practice, um, your technology does improve access and efficiency, okay? But it does not eliminate the need to verify rules, deadlines, and filing requirements. So, an e filing portal that is accepting your document does not mean that you filed it correctly. It does not mean that it's in the right court. It does not mean that it is by the right deadline. And it does not mean that it's in the right format. Okay? All of that verification is still on you. Okay? Take that very seriously. And I want to give you just like a quick kind of cautionary example from real practice that is, generalized enough that it's not going to point to like a specific case, but a filing that gets submitted through an e-filing portal, 1 minute after the midnight cutoff for a court, that treats the deadline very strictly, and the system, logs it as untimely. No exceptions, no grace periods, right? The portal doesn't care that you worked late in good faith. The system simply records the timestamp. Okay, and that's the kind of detail that you're expected to know. I mean cold, like down pat, okay? For every court you file in, you need to know the local cutoff time, whether it's midnight in the court's own time zone or if it's in the filer's time zone, and what happens if a filing is rejected for a technical formatting error that's close to the deadline. All right. Um, Remote proceedings, they also kind of raise their own set of practical little hiccups that are worth talking about too, like a witness that's testifying by video, from another state. It raises questions about how exhibits get shown and marked, for the record. How a court reporter is going to capture the testimony very cleanly if the audio connection isn't perfect, and how the attorney is going to handle objections in real time without like the natural pauses of an in-person courtroom. Okay, so none of that is impossible to manage, but it's now routine in a lot of courts. But it does mean that the pre-hearing logistics, so to speak, like the testing the technology in advance, confirming exhibit sharing procedures, all of that stuff is typically going to fall to the paralegal who is supporting the case. All right, so we've talked this kind of first third about the court structure. Now let's talk about the jurisdiction itself. Everything we discussed so far, the trial courts, the appellate courts, the federal and state systems, was just kind of our scenery, okay? Jurisdiction is where the actual legal analysis begins, and this is part of the chapter most likely to show up in some form in nearly every case that you ever touch as a paralegal, regardless of practice area. Okay? Jurisdiction, in plain terms, is a court's authority to hear a dispute and to make a decision that is actually binding the parties. Okay? Notice both halves of that definition. There has to be the authority to hear it, and there has to be the authority to make a binding decision. Okay, so a court might listen to your case and still lack the power to issue a judgment that means anything if it lacks jurisdiction. Okay, so we're going to work through a couple of, three related concepts today. And I want you to kind of picture them as three separate little gates that a case has to pass through, not three names for the same thing. Okay. Subject matter jurisdiction is the power to hear this type of case. Does the court even have the authority over disputes like this one at all? All right. Personal jurisdiction is the power to make a binding decision affecting this particular defendant or party. Does the court have the legal authority to reach out and bind this specific person or company? And then venue is the proper, geographic location for the lawsuit within whichever court system has authority. Assuming we're in the right system, which specific courthouse or district is the correct one. Okay. So Let's talk about this, when it comes to practice, okay? Because you're going to use this order every single time that you approach a court selection problem. First, you're going to ask which court system has the authority. Is it federal? Is it state? Could it be both? Because that is a possibility. Second, you're going to ask whether that court has power over the parties, personal jurisdiction. Okay. Third is you're going to ask which geographic court location is proper. That's the venue. Okay. System, then parties, then place. All right. If you get the order backwards, like for instance, arguing about, venue before you've even established like the court has subject matter jurisdiction, then you're building on sand. Okay. There's no other way to put it. And I like to use a simple analogy here. Think of subject matter jurisdiction as choosing the right building, okay? A courthouse that is even allowed to hear this type of dispute or this kind of dispute at all, okay? Personal jurisdiction is then about whether that particular building has the authority to make a decision that actually binds the specific people that are standing, in front of it. All right. And then the venue is about which door of that building, which room, like down the hall, is the correct one for them to walk through. Again, all three matter, and skipping any one of them can get your case thrown out despite the enormous amount of work that you're going to end up putting in. Okay. Let me also flag the word binding. All right. One more time, let's talk about it because it does the work, okay? A judgment that isn't binding on the losing party is essentially worthless. All right. The winning party can't collect on it. They can't enforce it. They can't rely on it for any future proceedings. That's why courts and lawyers, appearing before them take the jurisdictional analysis so seriously at the beginning of a case. They pour years of work and money into litigation only to end up with an unenforceable judgment. And that's one of the biggest, most expensive cases that a litigation team can actually make. Now, let's talk about subject matter jurisdiction specifically, because this is our very first gate. And if a court lacks it, nothing else matters. The case simply cannot proceed from that point. It does not matter how convenient it might be otherwise for the parties, okay? Courts generally fall into two categories here. You have a court of general jurisdiction, and they have the authority to hear many kinds of cases, except matters that are exclusively somewhere else, okay? So like a state's general trial court, their superior court, the circuit court, whatever it's called locally, is a court of general jurisdiction. It can hear contract disputes and family law and property disputes, personal injury, things like that. Most civil matters, again, unless there is some specific law that has like carved out an exclusive jurisdiction for another court. All right. A court of limited jurisdiction, has the authority only over specified cases. Okay. Small claims court, it's limited. It can only hear disputes up to a certain dollar amount. Probate court, it's limited to wills, estates, guardianships, things like that. Bankruptcy court, it's limited to bankruptcy matters. Okay. And federal courts as a whole are courts of limited jurisdiction, which is what I've already, kind of talked about. Again, that authority comes from the Constitution or from Congress in terms of what they're allowed to do. But it isn't like a general catch-all type authority in the same way that the Superior Court is on the state level. And here's a way to kind of make the distinction stick. Imagine walking into like a general trial court and a probate court with the same exact contract dispute. The general trial court can hear it because contract disputes fall within its, very broad authority. The probate court cannot. And it doesn't matter, again, how well drafted, how well researched. It doesn't matter because a contract dispute simply isn't one of the specific categories of cases that court was created to handle. So you're going to be turned away. The case is going to be dismissed regardless of its merits. All right. The rule here to internalize is very simple but absolute, and that is that a court must have subject matter jurisdiction before it can decide the case. Full stop. Okay. Unlike some other objections that we'll talk about later, this one cannot be waived. It cannot be agreed, around by the parties, and it can be raised at any point, even by the court itself, on its own initiative. So if a federal court realizes partially through a trial, like I said already, that it never actually had subject matter jurisdiction, that it has to dismiss the case. Even if neither party has even objected to it, they still have to do it. Okay. And think about how disruptive that actually is in practice. I mean, imagine a case that's litigated for 2 years. It goes all the way through discovery and reaches like the eve of the trial, only for someone to realize that the case never actually satisfied diversity jurisdiction or something, which we'll talk about that too. All of that work in federal court could be undone and the case would have to start over in the correct forum. So that's why confirming subject matter jurisdiction accurately at the very beginning of the case is not just like a box that you check once and forget. This is our foundation. All right. So it's worth double checking again when new facts come to light. So, given that federal courts have limited jurisdiction, what are the actual doors into the federal court for a civil case? There are three main categories, and this slide right here is just to kind of give you an overview. The first and probably the most intuitive is the federal question jurisdiction. This applies when a claim comes up under the U.S. Constitution, a federal statute, or a treaty. Okay. So if you're suing under, say, Title VII for employment discrimination, or like under a federal patent statute, or you are asserting a claim under the U.S. Constitution directly, say like a civil rights claim against a government actor, then you have a federal question, okay? And a federal district court is available to you regardless of where the parties are from or how much money is at stake, okay? Notice what's absent from that sentence. There's no citizenship requirement and no like dollar threshold here, okay, for the federal question jurisdiction. So a plaintiff and a defendant who both live in the same state can still be in federal court together so long as the claim itself comes up under the federal law. All right. Now, what arises under federal law actually means that itself has generated like a fair amount of its own case law, okay? But generally, the federal issue has to appear on the face of the plaintiff's own, what's considered a well-pled complaint, and not just show up later as like a defense that the defendant happens to raise, okay? And we'll talk about this more in detail as we move through the semester. The second is diversity jurisdiction, and it's diversity of citizenship. And we're actually I'm gonna expand on this a little bit more because it has more moving parts. But in the most condensed version, it applies when the opposing sides are citizens of different states, and the amount in controversy exceeds $75,000. Okay. And it's subject to a set of, technical governing rules that we're going to talk about. The third is the federal basis. And this is going to be situations where the U.S. is the government. It's a party to the lawsuit. Or where like a federal statute specifically authorizes federal jurisdiction over a particular kind of claim without it having to be, a constitutional question or, requiring diversity or anything like that. Certain federal statutes like securities law or certain intellectual property statutes, you have your maritime law, your admiralty law, those all carry their own built-in grants of federal jurisdiction. So if the federal government, say, sues a contractor for fraud on a government contract or gets sued by like a citizen under a statute that waives like government immunity from the suit, that's a federal case regardless of citizenship or the amount in controversy, simply because Congress said so, or at least it said so for that category of dispute, okay? Now, I do want to state that this is just an overview. It's not like an exhaustive list, and I mean that as like a genuine practice point here, not just like a disclaimer. But your jurisdictional statutes, they get amended. Courts interpret them in ways that shift over time, and the amount in controversy figure itself is set by Congress, so that could change. Okay. Always verify the current statute and procedural rules before you rely on any of that in actual practice, okay? Never file or like advise a client, based on what you remember from a class that you took years ago without double checking the current law, okay? And one more habit that's worth building now is that whenever you are evaluating whether federal jurisdiction exists, it is often useful to try and, to actually try like each basis separately and see whether or not it independently supports the case rather than like blending them together. Like ask, does a federal question jurisdiction work on its own with these facts? Then separately ask, does diversity jurisdiction work on its own, like with the parties and the amount that we're suing for? Okay. A case doesn't need to satisfy every possible basis, but it does need one that's going to actually hold up. All right. And you don't want to be like, you don't want to be putting them together because that's going to tend to produce like some sloppy analysis and you're going to end up missing gaps. All right. Now, I told you we were going to talk in more detail about diversity jurisdiction. And that's because on paper, I feel like it sounds more simple than it is. Different states, more than $75,000. But as the slide says, there's an important and genuinely technical basis for federal jurisdiction, and it's the one that trips up a lot of people in practice more than any other. It is going to start with citizenship because it's not as obvious as where do you live. All right. For an individual, citizenship generally follows domicile, and that is where the person actually lives with the intent to remain, not just wherever they happen to be at the moment. Okay. So a person who grew up in Georgia but has lived in Texas for the last 5 years, intending to stay there is a citizen of Texas for diversity purposes, even if their driver's license still technically says Georgia. Okay. For a corporation, the rule is going to be different, and this is where it starts getting technical. So, a corporation's citizenship commonly includes both its state of incorporation and its principal place of business. Both, not one or the other, okay? So, our earbud company, from our hypothetical, let's say that it's incorporated in Delaware, which is extremely common, by the way, for corporations, regardless of size, because Delaware has very well developed, corporate law. It's very corporate friendly. So let's say that it's incorporated there, but its actual headquarters and operations are its nerve center. That's what we call it. It's in California. Okay. That company is a citizen of both Delaware and California for diversity purposes, not just one. Okay. The second element is complete diversity. And that generally means that no plaintiff may share citizenship with any defendant. Okay. And I want to emphasize the word any there because this is where people get tripped up in multi party cases. So if you have a Georgia plaintiff suing a California defendant and a Delaware defendant, that is completely diverse. No plaintiff shares citizenship with any defendant. Like you can't put them on a piece of paper and draw a line across and meet anybody, so to speak. You can't connect anybody. But if you add a second plaintiff who happens to be, say, a citizen of Delaware into this same exact lawsuit against the Delaware defendant, then your diversity is destroyed for the whole entire case. Even though the original Georgia plaintiff versus California defendant piece was perfectly fine on its own. All right. Now, there are specialized exceptions to this rule in certain contexts. For example, some class action, suits are governed by different, more permissive statutes. But as a baseline, one overlapping citizenship anywhere in a case can knock out diversity jurisdiction completely. Okay. And let's kind of sit with why the rule is this strict. Okay. The whole theoretical justification for diversity jurisdiction is protecting an out-of-state party from potential home court bias in a state court. So even if one plaintiff and one defendant actually share the same state citizenship, that particular justification breaks for the whole, or it breaks down for the case as a whole. So Congress and the courts have insisted on, completeness rather than a more loose, like mostly diverse standard. Okay. The third element is the amount in controversy. Now, for an ordinary case, the amount generally must exceed $75,000. That's exclusive of interest and costs, meaning that you don't get to pad the number with, interest that's accrued or like the cost of litigation to push it over the line. And over the line means 75,000 and a penny or more. Okay. It has to be the underlying claim itself. So courts generally accept the plaintiff's good faith claimed amount unless it appears with, to like legal certainty that the claim is just really worth less. I don't want to say worthless, but worth less. So this isn't usually like a hard fought battle in most cases, but it can absolutely become one if the underlying damages are modest and then you have a defendant who wants to knock the case out of federal court entirely by challenging the number. Okay, so going back to our earbud fire, a ruined laptop, damaged furniture, other, associated losses, maybe they could clear, that $75,000 threshold based on what was actually destroyed. But that's a factual question that the litigation team would need to kind of nail down with real documentation before relying on diversity jurisdiction. Okay? Picture two versions of this same case. In version one, the fire destroyed, a basic laptop worth $1,000. Maybe burned the desk. Inexpensive, but total losses maybe $5,000 total. Okay. That case, even though it's completely diverse in terms of citizenship, it's not going to satisfy the amount and controversy requirement. And diversity jurisdiction in that case is not going to be available. The case would have to proceed in state court unless there is some other federal basis that exists. All right. Now, in version two, let's say that the fire spread further and it destroyed, the home office full of specialized like equipment requiring, I don't know, extensive like smoke damage remediation or something like that to the whole house. Caused the homeowner to lose like several weeks of freelance income. Well, now we could be well over the 75,000, and diversity jurisdiction now becomes a live option. The case, it doesn't have to have, 75,000 and a penny exactly. It has to show the potential. And when you're factoring in, this remediation, you're factoring in the damage, you're factoring in the lost income, it has that. Okay. Same defect, same basic legal theory, but very wildly different jurisdictional outcomes. And it's purely because of that dollar figure. Now let's talk about how state and federal jurisdiction interact with one another, because it's not always an either or kind of proposition. And there's a third concept, which is supplemental jurisdiction. That lets the two systems work together on a single case, okay? So exclusive jurisdiction means only one court can hear the case. So that claim must be filed in that system and nowhere else, like bankruptcy. So federal bankruptcy jurisdiction, you cannot file anything but bankruptcy in that case. In that particular court, you can't file it like in a state court or anything. It has to go to federal bankruptcy court. Patent claims work the same way. They're exclusively federal. Concurrent jurisdiction means that more than one court system can have authority to hear the matter. Okay, so both federal and state are appropriate potentially to hear it. That means that the forum selection still matters enormously because the party that's filing the case usually gets to choose, at least initially, and then that choice is going to have its own like real strategic kind of weight when it comes to like looking at the different procedural rules, different juries, different judges, sometimes even different like substantive law depending on the actual claim. And then there's supplemental jurisdiction. This solves a very practical problem. What happens when a case has one claim that clearly belongs in federal court and then a second related claim that on its own would only belong in state court? Well, then a federal court can sometimes hear that related state claim alongside the federal claim rather than forcing the plaintiff to litigate essentially the same set of facts in two separate courts. Okay, so like our earbud complaint, right? Our plaintiff has a federal claim saying that a federal consumer protection statute claim is proper here, but they also might still have, your kind of like garden variety kind of state law negligence claim that arises from that same fire. Okay. Supplemental jurisdiction can let the federal court hear both together, and it's in the interest of efficiency so long as they arise from the same set of underlying facts. Okay, but and this is the point that I really want to kind of land here. Don't assume that every state law claim automatically belongs in federal court just because one federal issue happens to be present somewhere in the case. Supplemental jurisdiction has its own limits, and federal courts can, and they sometimes do, decline to keep to keep the state law piece, particularly if the federal claim gets dismissed early on and then only the state law claim remains. Okay, here's a scenario to kind of like show you what I'm talking about. Let's say that the federal consumer protection claim in our earbud case gets dismissed, like 6 months into litigation because the statute simply doesn't cover this kind of product, right? Well, what happens to the remaining state law negligence claim that had been kind of, riding the coattails under the supplemental jurisdiction? Well, the federal court has the discretion to keep it and decide it anyhow, in the interest of judicial economy, or they can send it back to the state court, particularly if the case is still in its early stages. But there's no automatic answer. It's going to depend on factors like how far the litigation has, progressed, whether the remaining state claim raises like a novel or a complex question of law that a state court is better positioned to decide. Now, we spent a little over an hour on subject matter jurisdiction and court structure. So let's kind of shift the gates entirely and talk about the personal jurisdiction, which is a completely different question from subject matter jurisdiction, even though, students do tend to kind of blend the two together. But personal jurisdiction is the court's power to make a decision that's binding on a party. And this matters especially for the defendant because plaintiffs choose to walk into a particular court voluntarily by filing there, but defendants get hauled in. Okay, and due process requires that there be some legitimate basis for the court to exercise that kind of power over someone. Now, there's a few different routes in order to get personal jurisdiction. The most straightforward is resident defendants. So a state generally has personal jurisdiction over a defendant who actually resides in that state. So if our earbud company were headquartered in Georgia, this would practically be a non-issue, okay? But our defendant is in California, and we need the second route here, which is the non-resident defendants. So jurisdiction can exist over a non-resident if the long-arm statutes permits it and due process gets satisfied. Two separate requirements, okay? Both have to be met, okay? And we're going to spend the next few minutes kind of unpacking exactly what that means because it's really the crux of our hypothetical here. There's also a third route that's worth knowing, and that is the consent and waiver, okay? A party can simply consent to the court's jurisdiction, for example, through a forum selection clause in a contract or agreeing in advance that, any dispute will be litigated in a specific, state's court. Think about like the fine print in a contract, which I already mentioned that as an example. A lot of consumer contracts, software services, or there's terms of services, employment agreements, they have exactly that kind of clause precisely because it lets the company lock in a predictable, favorable forum in advance rather than leaving it to a case-by-case minimum context fight later. And I'm going to explain minimum context in just a second. And personal jurisdiction objections, unlike subject matter jurisdiction, they can be waived if the defendant doesn't raise them properly and promptly, like timely, okay? So if a defendant answers the complaint, they litigate the case for months, and then they try to argue that the court never had personal jurisdiction over it, that objection has likely been lost, okay? Sharp contrast with that subject matter jurisdiction, which can be raised at any time, even by the court itself. Personal jurisdiction is much more fragile, and it has to be asserted very early or it disappears. So let's dig into that non-resident defendant route because it's the only one that applies to our earbud company, and it's built on two separate steps that have to be satisfied. Step one is state law. A state long-arm statute is going to describe when its courts may exercise jurisdiction over non-resident defendants, okay? This is a statute that's passed by the state legislature. Okay, Georgia has one. California has one. Every state has some version. Okay, these statutes typically list categories of conduct that will trigger jurisdiction, like transacting business in the state, committing a tortious act within the state, causing an injury in the state through products sold or distributed there, owning property in the state, other similar categories. But some states, like California, has a very notable example. They have adopted long arm statutes that reach as far as the Constitution itself permits, essentially collapsing step one and step two into a single due process inquiry. Other states, like Georgia, we have long arm statutes with more specific enumerated categories that a court has to match the defendant's conduct against, sentence by sentence. Okay. So step one is purely a statutory reading question. Does the text of the relevant state's long arm statute, as written, reach what this defendant actually did? Okay. Step two is due process. So even if the long arm statute technically reaches the conduct, the exercise of jurisdiction still has to satisfy the due process clause of the United States Constitution. So are the defendant's contacts with the forum, are they sufficient that it's fair and reasonable to make them to defend the lawsuit there? Okay, this is where I want to introduce one of the most famous cases probably in all of American, civil procedure, because it does set the framework for what we still use today. And it's International Shoe Company versus Washington. And it was decided by the U.S. Supreme Court in, I think it was 1945. But the facts of the case are worth knowing because they're genuinely a useful kind of mental anchor. But International Shoe was a Delaware corporation, and it had its principal place of business in Missouri, right? But it had these salesmen who regularly solicited orders for shoes within the state of Washington. So they would go around and they would take orders and then they would send it back to Missouri for it to be filled, and then it would get shipped from Missouri to Washington. Now, Washington's unemployment compensation agency, they tried to assess taxes against the company. And the company argued that Washington's courts had no power over it because it wasn't physically present in the traditional sense, had no office, no formal place of business. So before this case, the courts largely required a defendant to be physically present within a state to be sued there, tracing back, to older, more territorially based kind of notions of power. Okay, but Shoe changed that. They established what became known as the minimum contacts framework. So the idea that a defendant could be subject to a state's jurisdiction based on its contacts with that state, even without the formal physical presence, so long as exercising the jurisdiction does not offend what is called traditional notions of fair play and substantial justice. So that phrase, the fair play and substantial justice, has become kind of the touchstone that the courts still apply today. Many years later, whenever they analyze whether or not reaching out to bind a non-resident defendant is constitutionally permissible. So just kind of remember this two-step structure. First, does the state's own long-arm statute, as a matter of statutory text, reach this defendant's conduct? Second, independently, does exercising jurisdiction satisfy constitutional due process under the minimum context framework? So a yes to the first question without a yes to the second still fails. Okay, you have to have both. Now, minimum contact sounds like a pretty clean, easy legal test, right? But applying it genuinely fact specific is a little nuanced. So I want to walk you through a few examples so that you can see how the courts actually kind of draw that line. Because despite being tested on or anything like that, in practice, you're going to be handed a fact pattern and asked to apply exactly this, okay? The core question is always, did the defendant deliberately create meaningful ties with the forum state? And you've got to notice the word deliberately, okay? Contacts that are accidental they're random, or they're entirely like the result of someone else's choices, generally don't count the same as contacts that the defendant purposefully created themselves. Okay. Now, on the likely meaningful contact side of the ledger here, you have think about like regular sales into the state, employees, offices located there, transactions specifically targeted at residents of that state, contracts entered into with parties of that state, advertisements soliciting customers from that state, or for like our own hypothetical, conduct connected to the actual lawsuit that is taking place in that state. Okay. So, a related landmark case that's worth knowing about is Worldwide Volkswagen Corporation versus Woodson. And this was also decided by the Supreme Court in the early, I want to say it was like 1980s, but it was early 80s, if not 1980. But in that case, a family bought a car from a dealership in New York, and they were later in an accident that ended up severely burning, I believe it was the wife. Anyhow, they sued the New York dealership and the regional distributor in an Oklahoma court because they were driving to their new home in Arizona. Anyhow, they sued in the Oklahoma court, arguing that the car's placement of the fuel tank made it prone to fire. Okay, so the Supreme Court held that Oklahoma lacked personal jurisdiction over that dealership and distributor because they did nothing to purposefully serve the Oklahoma market. They didn't sell cars there, they didn't advertise there, they didn't have any offices there. The car ended up in Oklahoma only because the family on their own happened to drive it there. Okay, so the case distinguished between a company that merely happens to have its product carried into the state by this, unilateral act of the consumer versus the company, Shoe, that purposely availed itself to the privilege of doing business in that state. They were deliberately reaching into that Washington market. Okay, hopefully this makes sense. This is why I like teaching this in person, because I like to be able to kind of stop and reflect on this if we need to. But on the more uncertain context side, kind of think about the merely passive websites that anyone in the world can view. Okay, but it isn't specifically targeting any one state. An isolated or accidental contact, like say a single one-off transaction that just happened to involve someone from that state. Or like an attenuated, like indirect connection several steps removed from like the defendant's own conduct, right? These may or may not be sufficient, and it's going to depend on the totality of the circumstances. We're looking at all the facts. Okay. Courts sometimes describe websites on kind of a sliding scale, like a fully interactive site where the company, knowingly transacts business with residents of a given state, taking orders, shipping products there, looks a lot more like purposeful availment than like a static kind of purely informational site that just happens to be viewable from anywhere in the world with no like state specific targeting at all. Okay. And here's like an example for you that they give you down there at the bottom. And it does kind of map directly into our hypothetical, but like a company that regularly sells a product in a state can be subject to a suit there for injuries that arise from those sales. Okay. Now apply that to our earbud company. If it operates a nationwide e-commerce business, it actively ships products into Georgia on a regular, ongoing basis, and this particular consumer's purchase and injury arose directly out of one of those sales, then that starts to look a lot like purposeful availment. You have regular, ongoing sales into Georgia, and that injury arose directly from that very activity. Okay. That's very different from, say, like a tiny local California boutique whose website happened to be viewed once by somebody in Georgia, who drove across the country and bought the item in person in California. Same general kind of fact pattern, but online sale, product defect, but the degree and the nature of the company's contacts with Georgia would look completely different. And that difference is what this personal jurisdiction analysis turns on. Now let's round out the jurisdiction discussion with two related concepts that you're going to encounter less often in the day-to-day, but do show up regularly enough, especially like in a property dispute, that you at least need to recognize them. The first is in rem jurisdiction, and that is where the court exercises authority over property that's located within its boundaries, and the property itself is the actual subject of the dispute. So think of it like a lawsuit for quiet title to a piece of land, or like a foreclosure action, or an admiralty action like against a ship. Okay, the court's powers here come from the property's physical location within the court's territory and not from any particular connection to a specific person. Now, the quasi in rem jurisdiction is a related but distinct concept. The court's authority is going to involve property that's connected to a person, but the actual dispute may concern like a personal obligation, so like a debt or a judgment, rather than the title to the property itself. Okay. A classic example is like a plaintiff attaching a defendant's property located within the state as a way of obtaining jurisdiction to litigate an unrelated personal debt, but using the property's presence as the jurisdictional kind of hook, even though the lawsuit isn't even about the property that's, owned. Personal jurisdiction, it focuses on people. In rem focuses on property. So if our earbud company owned a warehouse in Georgia and the dispute somehow concerned rights to that specific warehouse, maybe a boundary dispute with like a neighboring property or something, then we would be looking at in rem jurisdiction tied to the property's location. But our actual scenario, a consumer that's injured by a defective product, is a personal jurisdiction question about the company itself, and not like a dispute about a piece of property that's located in Georgia. Okay. Kind of a more everyday example of NREM is like a mortgage foreclosure. Like the lender doesn't necessarily need personal jurisdiction over every possible claimant to the property in the traditional sense, because the court's authority flows from the property's location within that territory. Okay. And I raise NREM and quasi NREM mainly just so you can kind of recognize them when they do appear, and you can at least kind of correctly identify that they're kind of a different beast from your, personal jurisdiction analysis that we've just spent like the last 10 minutes on. Now we've cleared two of our three gates. We've cleared subject matter jurisdiction and personal jurisdiction. And now let's talk about venue. And I want to be really precise about how venue differs from jurisdiction, because this is exactly the kind of distinction that shows up on exams and whatnot, disguised as a jurisdiction question. Venue concerns the geographic district where the lawsuit can be properly heard within a court system that's already has, jurisdiction established. Okay. Put the two questions side by side. Jurisdiction asks whether this court has legal authority to hear a case at all and to bind the parties. Venue asks something way more narrow. Assuming that we have the proper court system, it's which geographic location within that system is the proper one, is which one's, correct. So some common venue considerations include like the locations of the defendants, the location of the events that have given rise to the lawsuit, locations of witnesses and records, the location of any relevant property, whatever specific like statutory venue rules apply to that jurisdiction. Because venue, unlike, constitutional due process piece of personal jurisdiction, this is a creature of statute and procedural rule. Okay. Venue is not the same as jurisdiction, and I'm gonna hound on that one. Okay. A court may have full jurisdiction over a case and still be an improper or simply an inconvenient venue for it. Think about our earbud case again. Okay. Suppose the earbud company does business and has meaningful contacts throughout the entire state of Georgia, meaning a Georgia court plainly has personal jurisdiction over it. but the specific fire happened in one particular county. The consumer lives in that county. The damaged property is in that county, and the relevant witnesses are there too. So a Georgia court sitting in a completely different, like distant county might still technically have jurisdiction over the parties and the claim, but the venue itself would be likely improper, or at least highly inconvenient. Okay. If it was placed in that distant county compared to where everything actually happened. All right. In the federal system, general venue rules are going to typically point to the district where any defendant resides. So if all defendants reside in the same state or, district where a substantial part of the events that gave rise to the claim occurred, sometimes both of those points, to the same place. Sometimes they won't, which is exactly why venue requires like its own separate analysis rather than just being assumed automatically from, wherever jurisdiction happens to exist. And I apologize for talking so fast. I just realized I looked at the time and I've just spent so much time kind of filling in with things that I don't know, maybe they weren't necessary, but hopefully you learned something from it. But anyhow, changing venue. It's not necessarily fixed once a complaint is filed. A party may seek to transfer or to change the venue under any kind of applicable procedural rules, and there are several grounds for doing so. The most straightforward is that the case was simply filed in the wrong district in the first place. So, like a plaintiff's attorney filed in a district that doesn't satisfy the applicable like venue statute, and the defendant moves to transfer it to a proper one. Okay. Another ground is pretrial publicity or like other circumstances that may prevent a fair trial from happening in the original location. This comes up in high profile cases where you have extensive like local media coverage and stuff like that that could potentially taint, an impartial jury pool. And a court, may grant a change of venue to protect the fairness of the proceeding. A third is the convenience of the parties and witnesses, and it is sometimes called the forum non conveniens in its kind of more dramatic form. Even though like the standard rule is simple, like even a technically proper venue can be transferred if the balance of convenience, like where the witnesses actually are, where the evidence is located, any kind of travel burdens on the parties, if the balance of that convenience clearly favors a different location, it can be transferred. And then under all of those, you have the governing venue statute or procedural rules. It has to actually authorize the specific transfer that's being requested. So you can't just ask a court to move a case somewhere more convenient based on like sympathy or anything like that. Okay. There has to be some sort of legal mechanism in place that authorizes that relief. Okay. And the party that's seeking the transfer has to fit its facts into that mechanism. Okay. So courts weighing like a convenience based transfer, motion is often going to look at, a whole, I don't know, like a whole cluster of factors together, like where the key witnesses are located, whether or not they could actually be compelled to attend the trial in the original forum, like where the bulk of the physical and documentary evidence sits, the relative like court congestion and case backlog in each potential location, which state's law would actually, govern the substantive dispute, things like that. No single factor is automatically decisive, so a court is going to weigh them together. Okay. As your practice point says here, your venue objections are procedural and timing sensitive. Just like personal jurisdiction, if a party sits on a venue objection too long, it may be lost. So you always check the controlling statute, the applicable procedural rule, and the local practice. Local rules vary, meaningfully from courthouse to courthouse, even within the same state. And essentially missing a locally specific requirement is a completely avoidable and completely embarrassing mistake, in all honesty. One more thing that's worth knowing is that when a case is removed from state court to federal court, and that's something that a defendant can sometimes do when the case could have been originally filed in federal court, venue questions can resurface, but in a slightly different form. And that's because removal has its own specific rules about which federal district the case kind of lands in. And that's a discussion for another day, but I mention it now so that the word removal doesn't blindside you if it comes up again. All right, so now let's pull all three gates, right? Subject matter jurisdiction, personal jurisdiction, and venue. Let's pull them back together and let's compare how each one gets challenged procedurally, because the differences here are they have real case altering consequences if you get them wrong. All right, subject matter cannot be created by consent. The parties cannot simply agree to let a court hear a case that it doesn't otherwise have authority to, in the way that they might agree to waive a venue objection, okay? And it may be generally raised at any time, including for the first time on appeal, all right? It can even be raised by the court itself, acting on its own initiative without either party even raising it. This is the most durable and the least waivable of the three. Then you have personal jurisdiction, which sits in the middle. It's often challenged very early on, typically by a specific pretrial motion or an affirmative defense. And we're going to talk more about those two as we get further in. But a defendant may waive that objection entirely by failing to raise it in the required manner and within the required time. Show up, answer the complaint on its merits without properly objecting to or without properly preserving the objection, which means that you didn't state the objection. Litigate for a while, and you've likely forfeited the right to challenge that personal jurisdiction at all, no matter how strong the underlying argument might have been. Okay. Venue is also usually challenged through a timely motion to dismiss, to transfer, or to change the venue under whatever rules apply in that court system. It is also waivable if not properly raised as an objection. But notice the pattern across all three. Subject matter is the most protected and least waivable because it goes to the fundamental authority of the court itself. It's a structural concern that's going to outlast what any individual litigant actually wants. Personal jurisdiction and venue, it exists largely to protect the individual defendant's own interest, like the right to not be hauled into an inconvenient or unfair forum. And a defendant is generally free to give up a purely personal protection like that, whether deliberately or simply by failing to assert it in time. This is why the very first responsive filing that a defense team makes in a case matters so much. A defendant's answer or its initial motion is often the last real opportunity to preserve personal jurisdiction and venue objections very cleanly. And a paralegal who helps, calendar and track those deadlines is protecting the client from losing those arguments that might otherwise have gotten the whole case dismissed or moved to a more favorable forum. Many jurisdictions require these objections to be raised together in a very, early motion, single motion, I should also say, rather than piecemealed across separate filings, okay? And they may miss that requirement, and a defendant, again, can inadvertently waive an objection that it never even got the chance to argue on its merits. I promise I'm almost done. Let's turn this into a practical checklist, a repeatable checklist, because again, in real practice, nobody works through this from, pure memory every single time. Good litigations teams use a systematic process, and I want you to have one as well. So step one is identify the claims and the legal basis. Okay, what causes of actions are actually being asserted and under what body of law? Step two, determine possible subject matter jurisdiction. Is there a federal question, a basis for diversity, or are we squarely in state court? All right. Step three, identify each party's citizenship, their residence, and any kind of relevant contacts. This is foundational both for diversity analysis and for the personal jurisdiction analysis. So it does need to be kind of nailed down with some actual, documentation and not just assumptions. Step 4 is to analyze personal jurisdiction over each defendant individually. So remember that in a multi-defendant case, you may need a separate personal jurisdiction analysis for every single defendant, because one defendant's contacts with the forum don't automatically transfer to the co-defendant. Step 5, apply the venue statutes and the court-specific rules to figure out the proper geographic location. Step 6 is check for removal, transfer, waiver, and timing issues. Like, has anyone missed a deadline to object? Is this a case that the defendant could remove from state to federal court? Are there any, other procedural traps kind of lurking around out there? Okay. And the very last one is to verify the current law before advising or filing. I keep repeating this point because, it's genuinely the most important habit that you can build. Jurisdictional rules, dollar thresholds, filing deadlines, these all get amended by legislatures and they get reinterpreted by courts. And if you rely on outdated information, it is going to be one of the most common and most preventable sources of malpractice exposure that happens in a litigation matter. Okay. As a rule that you learn correctly in this class in one semester could genuinely be out of date by the time you're using it in practice. Okay, so just kind of build the habit now of treating every jurisdictional rule as something that you need to re-verify against the current statutes and not something to just kind of recall from memory. Okay, but what does this look like, from the paralegal seat specifically as opposed to the attorneys? You're going to as you see over here on the right, you're going to prepare, a jurisdiction and venue fact chart, kind of laying everything out that's relevant, party by party. You're going to verify the information. You're going to confirm states of incorporation, principal places of businesses, individual domiciles, through corporate filings, other reliable sources, things like that. Not assumptions from a client intake form. Okay. You're going to locate the actual rules, the long arm statute, the venue statute, any kind of relevant procedural rules in their state in the current up-to-date form. You're going to calendar the deadlines for any jurisdiction or venue related motions. You're going to flag unresolved issues for attorney review. You're not expected to make the final call, legally speaking, but you are absolutely expected to spot the issue and bring it forward clearly. All right, so let's bring it back to our earbud hypothetical, because you now actually have like the full toolkit, and I didn't answer it initially, okay? Again, Georgia consumer, California company, product purchase online, battery fire causes financial loss. Walk through the checklist. What claim or claims might be asserted? Well, almost certainly a product's liability or negligence claim under state law. Defective design, failure to warn about, the overheating risk, and possible breach of warranty claim if there was an express or implied warranty involved in the sale. Okay. Is there a federal question basis? Probably not, based on the facts alone. A straightforward products liability claim is ordinarily a matter of state law and not federal law, unless some specific federal consumer like safety statute happens to apply, which we would need to research. Is diversity potentially available? Quite possibly. Georgia consumer against a California and Delaware citizen corporation is diverse on its face. So the real open question there becomes the amount in controversy. Like, does the value of the laptop, the furniture, and any other losses, does it clear $75,000 and a penny? Okay. And that's a factual question that the team would need to substantiate with documentation, receipts, repair estimates, appraisals, things like that before relying on it. What facts show or undermine personal jurisdiction in Georgia? Well, we'd want to know, does the company regularly I don't want to say but regularly and deliberately, sell products to Georgia customers as part of its ongoing business? Or was this some kind of like unusual isolated transaction? Does it have any employees, warehouses, or advertising specifically targeted at Georgia? Like, did the injury arise directly out of the very sales activity that's connecting the company to Georgia? The stronger and more deliberate that the connection looks, the stronger the personal jurisdiction argument for suing in Georgia will be. Okay. What venue options could be appropriate? Well, assuming that Georgia has both subject matter and personal jurisdiction, then venue would likely point to the specific county where the consumer lives, where the fire occurred, and where the relevant evidence and witnesses are located. And finally, what additional facts would you need before actually recommending a forum? So that's the question that I want you to kind of like sit with. A strong answer to a jurisdiction problem identifies the missing facts rather than just kind of, confidently guessing past them. All right. We'd want the company's actual sales volume in Georgia, its corporate structure and citizenship confirmed through its official filings. We want a real dollar figure for the damages, and we want a careful read of the current long arm and venue statutes. Jurisdiction analysis is rarely a single label, one sentence exercise. It is a layered judgment call that's built on facts that you have to go out and actually confirm. Okay. Now, notice how far we've come from like the opening slide where the same fact pattern felt maybe a little more impossible to answer. And it wasn't necessarily a trick, it generally did require everything that we covered in between. And that's been the whole design of this particular chapter. Court structure. And it told us what kind of court we're even talking about. Subject matter jurisdiction told us whether federal court was a realistic, option on the table. Personal jurisdiction told us whether Georgia could reach the defendant at all. And venue told us what specific courthouse within whichever system we choose is the right one. And every one of those pieces needed to be worked through in order, and skipping any single one of them would have left a gap in the analysis. And even after working through all 6 steps, we still end with open questions rather than a single confident answer. And that's not a failure of the analysis. It's actually what a competent forum analysis looks like at the intake stage of a real case. So the value that a paralegal adds here isn't pretending to have an answer immediately. It's building an organized, complete picture of what's known, what's still needed, and handing that off to the supervising attorney in a form that lets them make the final strategic call quickly and confidently. Remember, it's their license that's on the line. Now, ordinarily, I'd stop and we'd do a little bit of a knowledge check, but because this class is not being taught live and I can't get you to talk back to me, I'm not going to do it. So you can just stop and practice yourself if you want, or let it keep playing. And again, I'm not going to rehash this one either. You can pause to read. Let me know if you have any questions. You guys know how to reach me. Bye.